getting started today. There's a lot of busy activity going on at the Capitol with committees working on bills as we approach turnaround in the legislature. With that committee then, we have on the agenda to work bills that we have previously heard. And what I would like the committee to first take a look at is, yes, Senator Haley.
I'm sorry, Madam Chair, but it's certainly, to be consistent, we certainly want to wish the chair, all of us, I'm sure, today is your birthday, and on behalf of our committee, very happy birthday to you, Madam Chair. Thank you.
Thank you, committee. Appreciate that. We do have a lot of February birthdays on this committee. I think 4 of us, with Senator Pyle, Senator Bowers, and Senator Wilborn. So thank you, committee, and it's a pleasure to be working with everyone. Thank you, Senator Haley, for the birthday shout out. I won't ask you to sing or anything. So, but thank you very much. And then committee, we will look at Senate Bill 106. And Senate Bill 106, we heard last week, and it's regarding enacting the revised Uniform Law on Notarial Acts and repealing the Uniform Law on Notarial Acts. So it kind of brings up to date how notaries proceed and e-notarization we talked about. Is it a secure process? What kind of authentication do you have to have as the person who's getting the notary to notarize your document? And if we could start then with a bill brief from the reviser, Mr. Thompson, if you're on the call, that would help us take a look at the bill again.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the reviser. As the chairperson said, Senate Bill 106 does enact the revised Uniform Law on Notarial Acts and repeal the Uniform Law on Notarial Acts. It also repeals some provisions related to notaries public in another article of Chapter 53 of our statutes, mostly some conforming amendments and things of that nature. The primary pieces of this bill are, replacing the current uniform law with the updated one, and the specific provisions that were discussed mostly in the hearing were the remote notarization, which led to the authentication discussion of how that would be conducted. There was also some discussion of recognizing acts performed in another state or another jurisdiction, and how that is recognized under the current act and is continued to be recognized under the new and updated act. I think that pretty much covers it, unless you have specific questions.
Thank you, Mr. Thompson. Could you remind the committee, this was heard and worked last session, is that right? And I think some amendments were made last session that are now incorporated into Senate Bill 106, is that correct? Go ahead,
yes,
Mr. Thompson.
Yes, thank you again, Madam Chair. This is Jason again. Yes, the bill last year, I'm trying to get you the bill number, was House Bill 2713. It did pass the House. I have to vote here. 122-3, and then when it got to this committee, it was amended. Those amendments are reflected in the bill. And then the only additional amendments made since last year would be updating the dates so that it takes effect a year later than last year's date.
Thank you, Mr. Thompson. And prior to the legislature adjourning last session, we didn't have in place a Kansas process for remote notaries, right? But this Senate Bill 106 codifies how we've been operating basically for the last year with remote notaries. Is that correct? Through HB 2016 and the prior bill?
Right. Thank you, Madam Chair. Jason Thompson again. You're correct that we have what's the appearance requirement is what the notaries were calling it. You have to appear before a notary under current law. The governor did waive that requirement in an executive order, and the legislature enacted a statute that authorized that action and validated any notarizations that occurred under those new rules under the executive order during the emergency declaration. This goes a step further and provides a whole statutory process for how you do those remote notarizations, the record keeping. And so it actually is a little bit more even than what we have now. But it does replace the appearance requirement in those cases, although you can still have a traditional notarization, of course, under our law. This is just another way that you can do it and have an appearance that is remote.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Seeing none, any discussion on Senate Bill 106? Seeing none, is there a motion regarding Senate Bill 106? Senator Baumgardner.
Thank you, Madam Chair. I move that we pass the bill out favorably.
Second, Senator Gossage, thank you. Any discussion on the motion? Seeing none, we'll vote on the motion to recommend Senate Bill 106 favorably for passage. All in favor, aye. All opposed, nay. The motion carries. Committee, we're working on documents addressed by bills today. So the next one we will look at will be Senate Bill 122. Senate Bill 122, we also heard last week, and it modifies certain rules of evidence in the Code of Civil Procedure related to authentication of records and documents. So again, document heavy today on the two bills we're looking at. If Mr. Reviser, Mr. Thompson could give us a reminder of the bill brief on SB 22, please.
Yes, thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 122 does modify certain rules in the rules of evidence in our Code of Civil Procedure. You heard from the Judicial Council conferee that this mostly updates our code to reflect some changes that have occurred in the federal Code of Civil Procedure. For the most part, Kansas follows the federal code with some Kansas-specific exceptions, and this would update certain rules to reflect those changes. The statutes in question are the hearsay evidence statute in 60-460, the authentication of a writing statute in 60-464, and authentication of copies of official records in 60-465, and the original document rule in 60-467. And the committee may recall that the bill was heard last year. It was 2020 Senate Bill 334. It did receive a floor action. It was placed on the consent calendar, actually. And so it passed the Senate off the consent calendar 39-1 last year and went to the House where it had a hearing in Judiciary, but then the session ended prematurely.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Seeing that, oh yes, Senator Wilborn.
Thank you, Madam Chair. Just a point of fact, it did pass the Senate last year 39-1. We did put it on the consent calendar. I am not recommending that today, but just a reminder, it was with ease of which it passed the Senate last year.
Thank you, Senator. Any further discussion on the bill or a motion? Senator Thompson.
Yes, I move we report Senate Bill 122 out favorably for passage.
Second, Senator Corson. Committee, you've heard the motion. Any discussion on the motion? With that, then, we will vote on the motion to recommend Senate Bill 122 out favorably for passage. All those in favor, aye.
Aye.
All those opposed, nay. The motion carries. Thank you, committee. We next have in front of us a bill that's been some time since we heard. It's Senate Bill 57. It's regarding statutory speedy trial rights. I just wanted to have the reviser remind us of the bill brief, please. And then I wanted to talk with the committee about what your thoughts are on working the bill. Are we ready to work the bill? What are thoughts on that? So if we could have the bill brief, please, that would be great. Thank you.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 57 does make changes to the statutory speedy trial requirement that is found in KSA 22-3402. The bill proposes to suspend the statutory speedy trial requirement in all criminal cases filed prior to the effective date of the act until May 1st of 2024. The bill also proposes to eliminate the speedy trial requirement for all criminal cases filed on or after the effective date of the act. And the amendments to the section would be construed and applied retroactively, and it would take effect on publication in the Kansas Register.
Thank you, Mr. Thompson. Are there any questions for the reviser from the committee? All right, seeing none. Committee, you'll remember that at the conclusion of the hearing, we had informally asked the proponents and the opponents of the bill to please meet, bring the committee a solution that you thought was workable. You know, we understand the concerns of both sides in this matter and of the courts. We didn't have any testimony from the judicial branch to hear from them. And they did. The two sides did work together. They have put together a joint proposed amendment that it's not a balloon amendment. It's not been through the revisor's office yet, so it's probably not yet ready to be worked. But if we could start thinking about it, and we do have a copy of it to pass out, and we do have a balloon amendment. So we're not going to pass that out yet. If we could have just a little bit discussion first. Yes, Senator Wilborn.
Thank you, Madam Chair. I felt compelled to offer my opinion on Senate Bill 57. First, I want to commend the prosecutors and the defense counsel for getting together, offering a compromise on a very serious issue. I have some heartburn. At the very least, I'm disappointed that the judicial branch did not appear before this committee, nor did the governor's office. After all, it was the governor's EO that brought us to this point. It was the judicial branch's plan that brought us to this point. And there's going to be a part two to this. We're going to have more to say as we go down through the path of fixing this up. I would hope that we could infuse some flexibility, some entrepreneurship like business and industries had to do through this pandemic. And this committee has been put, I think, in an awkward position, and the chairman has been put in an awkward position to finalize and to move this bill forward. With that, I do plan to support Senate Bill 57, knowing that there will be part two. Thank you, Madam Chair.
Thank you, Senator. Yes, Senator Haley.
Thank you, Madam Chair. I too feel that the committee has been put in an awkward position because of procedurally where we are. Though I disagree, this is certainly not something that was created by the governor. The governor's done, as have the governors of other states, the best they can to reconcile the constitutional right to a speedy trial with the backdrop of ensuring that the wheels of justice are fairly met. We are in a difficult position because of a pandemic, and finding a resolution to an unprecedented need to ensure the constitutional right to a speedy trial with the backdrop of the backlog of cases that has been formed not by one entity, but because of a global pandemic is what has put us in this awkward, as was, I think, an accurate word, position. As the bill gets worked, I'm looking forward to how we find a resolution. I will share with the committee that I do not support the current sunset of 2024. We'll be hoping that we can have a more, if you will, expedient date to work this out. And we'll look forward to what other potential amendments could be added for a cleaner and more effective resolution to, again, an awkward situation. Thank you, Madam Chair.
Thank you, Senator. Senator Thompson.
Thank you, Madam Chair. I concur with the Vice Chair's assessment of this situation. And if you look at, talking to the various opponents and proponents, we understand the position they are in. This is not going to be cleared up until we open this state back up. North Dakota, Montana, Iowa just dropped their mask mandates. Florida has been wide open and doing just fine. We need to get this emergency over so the courts can start doing their job. And I think the faster we do that, the quicker this problem will start to clear itself up. And the more that we delay that effort, the more problems we're going to have. And so this is, again, I agree with the Vice Chair. This is a very awkward position. We don't want to see people sitting in jail any longer than they have to or waiting to get their due process. And I'm very concerned, but obviously I will support the bill because I think everyone that took their time to come before this committee expressed that need. And thank you for your time.
Thank you, Senator. Senator Corson.
Thank you so much, Madam Chair. I do have an amendment that I had planned on working, which I had deferred reaching out to the revisor's office in the hopes that we would have, obviously, sort of a consensus agreement between the different interests that we could all support. So I would, of course, very respectfully defer to whatever the chairwoman decides. But I would I guess you would like time to maybe work on an amendment if we don't have this sort of agreed upon consensus. And one issue that I wanted to raise that for just the committee's consideration is I felt like that we've sort of combined two separate issues, one being what we need to do with respect to this backlog because of all of the issues related to COVID and the response. And then the second issue would be, getting rid permanently of the statutory speedy trial right. My view is that those are separate issues, and I think that, and this would be reflected in my amendment, that maybe the committee should separately hear testimony on the statutory speedy trial right and see if that is adequately working, if changes need to be made. But I felt like the bulk of the testimony and our conversation focused on the immediate backlog and the pressing issues that's created. And so if we get to that point, something that the committee would see in my amendment would be to strike the getting rid of on a going forward basis the statutory speedy trial right, because 40 states have a statutory speedy trial right. I'm open to the idea that ours may be able to be improved or tweaked or modernized, but I thought that maybe it may be beneficial to kind of separate that issue out, because I think it's separate from the immediate challenge that we're facing, and maybe have some specific testimony about what are other states doing, does ours need to be improved. So that is just my suggestion, and thank you very much, Madam Chair.
Thank you, Senator. Thank you for all the comments that were shared and the discussion. I think it's timely. I understand the point raised by Senator Corson, and you'll find that the amendment I have to pass out does address your concern about should we get rid of statutory speedy trial right in total in Kansas or not. Want to make clear that Senate Bill 57 does not impact or revoke or take away constitutional speedy trial rights. This is solely statutory speedy trial rights, and I don't recall from the testimony how many states have statutory speedy trial rights. I'm thinking it was maybe 7 or 13. So we are not impacting a defendant's constitutional speedy trial rights. Those have different factors that a court can consider and take into account when it's a constitutional speedy trial matter, including the overall context of what has caused the delay, and that would be including the pandemic that we've been living and operating under in the constitutional speedy trial aspect. It is a difficult position that the legislature has been put in, so appreciate the thoughtful discussion. And with that, I would like to pass out the amendment that has been brought to us by the Kansas Association of Criminal Defense Lawyers and the Kansas County and District Attorneys Association, and just open it up for discussion. I heard that there might be a possible amendment from Senator Haley about moving the date. So I'm not saying that we need to conclude our work here today on this bill, but I do want the committee looking at how we can move this issue forward. And if we need to wait for an amendment to be brought to us, we can do that as well. So with that, if you'll take a look at the amendment that's being passed out, it is the result of a signed joint proposed amendment regarding Senate Bill 57 by the entities that I stated. Those were the entities who also testified in support and against Senate Bill 57. And you can see on page 1, we can have the reviser explain the amendment, and then we can open it up for discussion. Mr. Reviser?
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office. Trying to show you the screen here. Hopefully you can see the balloon amendment on your screen, as well as those of you in the committee that have the paper copy. So the proposal here would strike elimination of the statutory speedy trial and provide guidelines for prioritizing trials. You'll see the content itself down on page 2. We would preserve the language in lines 18 through 20. The provisions of this section shall be suspended until May 1, 2024 in all criminal cases, period. And then we would strike all the provisions in lines 21 and 22 regarding eliminating speedy trial going forward after the effective date of the act, and replace that with some language about prioritizing cases for trial. The trial court shall consider relevant factors, including but not limited to the 6 enumerated there regarding calendars and relative prejudice and relative safety regarding public health. And again, these would still be construed and applied retroactively there in subsection L, so that's retained also.
Committee, any questions for the reviser? Senator Thompson.
Thank you, Madam Chair. So I'm assuming that once we reach that deadline date, this will sunset and will revert to the original speedy trial requirements, correct?
Mr. Thompson, are you able to answer that?
Madam Chair, this is Jason Thompson with the Reviser again. So the mechanics would be the same as discussed in the original bill. So the provisions of this section, all of the time limitations imposed by this section are suspended until May 1 of 2024. So after that date, all of those time limitations apply again.
Thank you, Madam Chair.
The interesting thing with the May 1st, 2024 date is that if the courts, the DAs, the criminal defense lawyers, if there's a problem as that approaches, it will be in this same Senate chamber that we will all be hearing this again as we get closer to May 1, 2024, if there's a problem with the judiciary meeting this deadline. So yes, Senator Haley.
Thank you, Madam Chair, and certainly it's going to be my hope that we revisit it if need be well before 2024, maybe as early as next year in 2022 to see how that backlog is going. Should this bill pass. For Mr. Thompson, providing, and by the way, I like the forethought of this amendment, Madam Chair. I think it begins to bring closer to the middle some of the obverse contentions of the proponents and opponents. I commend the language. My question for the reviser, Mr. Jason Thompson, is on points 2 and 6, the prioritization being relative prejudice to the defendant and the relative safety of the proceedings, et cetera. The question is, there's been a lot of discussion, in bail reform. Do we get to some of the tenets of those discussions regarding pretrial detention when we look at the relative public safety and the relative prejudice to the defendant? Has that been undertaken in some other discussions that he's aware of relative to this amendment and beyond?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson with the reviser again. There are ongoing discussions. In fact, I recently received a copy of the Kansas Judicial Branch's Pretrial Justice Task Force report. And there are ongoing discussions at the Sentencing Commission, the Criminal Justice Reform Commission, et cetera. But the point in this particular amendment is just to emphasize the relative prejudice to the defendant, because that is a factor in the constitutional speedy trial analysis. So they're, I think, directing the court to consider these factors that would also be considered in the constitutional analysis to make sure that they're prioritizing accordingly and not creating a compliance with the statutory requirements and causing a problem with the constitutional requirements on the back end that might cause a case to be dismissed with prejudice, as you heard in the testimony.
Thank you, Madam Chair. Thank you, Mr. Thompson. Just my two-sentence editorial that may go beyond the scope of the amendment, Madam Chair. But this committee has considered, and this legislature has passed legislation regarding the wrongful incarceration. Members on this committee now have heard that, and my concern about this entire issue revolves around those who will ultimately be found not guilty of the crime of which they've been accused, and extending that time for weeks, months, years that we detain someone who is accused of a crime of which they're not guilty, and how that filters down into the compensation on their lives or the time that they spent is the larger issue that looms, or a large issue that looms certainly for this senator in this discussion. And so when we look at the relative prejudice to the defendant, the court may make a preliminary determination as to, frankly, the evidence that pre-trial, the putative guilt or the potential not guilty verdict that would be rendered some point subsequent, maybe much further down the line because of this legislation that we enact. I know it was more than two sentences. I'm sorry, Madam Chair, but I just thought I'd thank you for allowing me to share.
Absolutely, Senator. Thank you. You do raise some valid concerns that have been raised in this committee, and I appreciate you bringing those forward. If you're held with no bond, you have received some procedural process to determine whether you can be released on bond, and the bond procedures, I've been told by the Kansas County and District Attorneys Association, they have been working on bonding out as many defendants as they can, and being very creative and working out plea bargains and things like that to address some of those very concerns. So while the bill and the amendment we're hearing are not ideal, it is a compromise, a resolution to move this issue forward. But I'm still entertaining discussion and thoughts, and if there are other amendments that we need to entertain those as well. Senator Pyle, you had a question or comment.
Thank you, Madam Chair. On the back page of this handout, second page where the strike is, and it strikes filed prior to the effective date of this act. Is it their intention to, it says the provisions of this section shall be suspended until May 1st, 24. The suspension includes, with the stricken language, at least just basically the case is up to the effective date of the bill. By striking that language, we're just saying everything goes. Everything can be suspended. Everything. I mean, there's no rush. We got till 2024 to work through these. I'm not sure I like that strike. I think that by keeping that language filed prior to the effective date of this act, we tell the courts and those parties involved, you're going to make a priority with the second part of this amendment here in the box of those cases prior to the passage of this bill of getting them done. And you have until 2024 to do it. We are just, with the strike, if I'm understanding it, you're going to add in more cases. I have an issue with that. Thank you, Madam Chair.
Thank you, Senator. With the amendment that has been brought to the committee by the parties who have reached a compromise, it would apply to Act 2, and Mr. Revisor can correct me if I'm wrong, it would act as, like you have stated, to suspend or waive statutory speedy trial for cases filed from the effective date of the bill where it become law until May 1st, 2024. That's my understanding of how the amendment operates. So, we need to have discussion if that's where the committee wants to go. I believe the compromise that is presented to us in the amendment was thoroughly vetted by both sides, on the defendant side, the prosecution side, and this is the solution they have brought the legislature. Yes, Senator Pyle.
I don't disagree with any of that, but the problem is the backlog to date, not cases coming from here on. But we are adding in all of the above from here on and beyond until May 1, 2024. We may make this problem 10 times bigger by adding that part. And so, I don't have a problem with the rest of the amendment. I think they should prioritize. They need the point 6, safety proceedings. They need to get it done. They're going to have to probably work a little overtime. But they can figure out a way to deal with this COVID situation and deal with the cases. These people still have a right to speedy trial constitutionally going forward. So any criminal cases from here on, in my opinion, shouldn't just be swept into this language. And that's what this strike does. Tell me if I'm wrong, Madam Chair.
Thank you, Senator Pyle. I'll just clarify, but so the issue I see as brought up as we're discussing this amendment is if we don't keep the striking through of the filed prior to the effective date of this act, so then the act becomes effective, this year, and then the courts would be facing the same problem of getting defendants to trial within 150 or 180 days of when this becomes effective, between now and July 2021, and they just don't, what we're hearing, I guess, from the Kansas County District Attorneys Association, again, we haven't heard directly from the courts, but what we're hearing from the prosecutors is they are not going to be able to meet this 150, 180 day deadline. If that clarifies a little bit, doesn't make you satisfied, but that's why we're having the discussion, so I appreciate that. Senator Thompson.
Oh, that answers my question. I was thinking about the same thing, Senator Pyle, and the backlog and how that's addressed. Obviously, you're adding more backlog as we go forward, and that was my concern about this whole pandemic. We've got to call an end to this emergency at some point, or this backlog will grow exponentially, and the problem will be perpetuated for years. So that kind of clears it up. Thank you.
Thank you, Senator. Yes, Senator Corson.
Thank you, Madam Chair. Given that, the parties, I believe all the parties are working and acting in good faith, and given that this is a compromise that they've reached, I'm very inclined to support it, knowing that because I think from all their testimony, I believe them to be good folks who are all trying to solve a difficult problem that we've been placed in. But to the extent we are going to open it up, I mean, my initial inclination was to try to amend this May 1st, 2024 to May 1st, 2023, just because we are touching on such a fundamental right, both statutory and constitutional, when we're talking about the right to a speedy trial, that I had, again, my preference would be May 1st of 2023 to bring the parties in. That's still more than 2 years away. That's quite a long time. A lot of these cases may plead out. They may be dismissed. There's oftentimes a resolution prior to a jury trial. And just to have everybody check in, understand what the backlog is, I would be very open to them saying that we do need an extension to May 1st, 2024, if that was what in May 1st, 2023 they felt like they needed. But it's just more than 3 years away feels like a very long time in a very uncertain world. And so I had thought, could we get folks back in 2023, do a check-in, see what that load looks like? And again, because they are good faith actors, I would not necessarily be opposed to extending it if that was what the testimony, was that was called for. So thank you, Madam Chair. I just don't know how others would feel about an amendment that would change it to 2023. I would just be curious if others on the committee had input. Thank you.
Senator Pyle.
Thank you, Madam Chair. I'm not so concerned about the 2024 date. We're giving them over 3 years. But right now, if we leave the stricken language filed prior to the effective date, if you keep that in place, you have a boxed amount of cases. By that date, whatever that date is, that this is passed and becomes effective, at that date, we can look back at all criminal cases filed that haven't been dealt with, and we know exactly what we're dealing with. The courts know what they're dealing with. But my understanding is right now, the courts have no plan to deal with these cases right now. But we don't know. We haven't heard from them. If there's a way to deal with it, they need a plan so that they can start working on this boxed amount of criminal cases. By striking the language, we need a bigger box. Why would we give them a bigger box when we don't have a plan? You don't do that. You figure out how to deal with what's in the box right now. That's what our first step should be. And it ought to come from the courts. They need to come in here and tell us, here's how we're going to do it. We're going to rent auditoriums. We're going to put people 6 feet of place. We're going to call juries in, and we're going to do the social distancing thing. Whatever. I don't know what that plan is. That's their problem. They've got to deal with it. But we need to know what that plan is before we increase these cases up till May of 2024. Maybe they'll never get dealt with, and then you've got a great big problem that's exacerbated. I can't go with this language of striking that language. I am not going to, I just have a problem with making this box that much bigger. And if somebody can console me on that and convince me otherwise, maybe I can change my mind. But at this point right now, I want to see a plan. And I want to see that they know how to deal with and are going to start dealing with these. These people have a right to speedy trial. That's in the Constitution. I'm not talking about statutory right that we create and now we suspend because the two parties have come together. We need to honor those rights. And the best way to honor them is say, give us a plan, show us how you're going to work with what's in the box right now, and then we can move forward. But that's kind of where I'm at, Madam Chair. So this discussion, I'm just sharing my heart. Thank you.
Thank you, Senator. You've heard suggestion about we haven't heard the plan from the judiciary. Would it be helpful to the committee if we had an informational hearing, someone from the judicial branch to come over and say, if this is going to be enacted, I'm seeing heads nodding and shaking yes, what is your plan to start today, if this bill were to become law, so that we can be ready to start addressing these May 2024, May 2023, whatever date we're deciding on. And I'm seeing kind of a consensus of the committee. We'd like to hear from the judicial branch before we finish our work on Senate Bill 57. Yes, I believe Senator Haley was next, and then Senator Baumgardner.
Thank you, Madam Chair, but with your suggestion, and certainly in light of what some of the other members have discussed, I certainly would like to hear or have, as I think you've indicated others would, the courts, the judicial branch weigh in on the original and the potentially amended language for 57. So, I mean, I guess you've rendered moot my concern, if in fact that is going to be the consensus. I will say one brief footnote. I was hoping that we would look at 2022 next year and to see what the plans are. If we set that date, there'll be an opportunity to evaluate how the caseloads have been managed in the higher jurisdictions, especially the more populated. It would not take much to take a census or an audit of where the caseloads were in 2022, and certainly if it needs to be extended, 2023 or 2024 even, we'd know. This whole issue with growing caseloads will be arrested within the next year. We are reaching that point where there will no longer be need of the elasticity of constitutional due process. I honestly believe that we're getting a grip on the pandemic. So let's just do it a year at a time. I'd like to see 2022 so we can take a look at it. And if need be, we'll go through this process then because the caseloads haven't shrunk. But thank you, Madam Chair. I look forward to the judicial branch's input on this legislation.
Thank you, Senator. Senator Baumgardner.
Thank you, Madam Chair. First thing I would like to do is respond to the point that the senator from Brown made with regard to that effective date being struck. It's actually struck, I highlighted, in 2 different locations, and we should be concerned about that in both locations that struck. The second is shall not apply in any criminal case. So that's one issue. The second issue is with regard to, you're talking about a 3-year extension. My goodness. Online, anyone that's in jail could get a law degree in those 3 years. So that's inappropriate. The third is with regard to judicial. We do need a plan, and I'm going to simply direct or suggest to the committee it needs to be a multi-pronged plan, because based on the testimony we received, the issues with regard to rural are very different from the issues of our suburban and our urban centers within our state. So with regard to rural, remember, that is a judge that travels around and serves up to 5 different counties. So there must be a multi-pronged address to that. And my fourth comment is, yes, we do need to hear from judicial, because by golly, in Ways and Means, we know that they have submitted their budget for 2 years out, and the governor has submitted her recommendation for judicial budget. So along from hearing from, as well as hearing from Judiciary, we do need to hear from the executive branch, because here's the bottom line. Since COVID was declared an emergency in March, we have had one after another executive orders. And why there's not an executive order to address this specific issue, because keep in mind, while Judiciary isn't spending money because they're not having trials, who is spending money? Well, our local jails, our county jails, they're spending money keeping all of these individuals in cells. And so where is the clawback? Where is the shift of funds from that? I'm certain it has not occurred, but we need to know something specific from the executive branch, because that's a branch that has remained silent on this issue. Thank you, Madam Chair.
Senator, thank you, Senator. Senator Wilborn.
Thank you, Madam Chair. Obviously, the date among this body, this committee, is a concern. Senator Corson made, I think, a compelling argument for backing it up at least to 2023, and maybe that's not the right date, but we all have a concern with that. Senator Pyle's comments about striking that language and the impact that has in the big box of files, that is a concern. And obviously, many have stated the concern that we haven't seen a plan. So we have a little work here, Madam Chairman. I regret that for your sake.
Thank you, Senator. Not afraid of a little bit of work, but it does look like we need to have some more information from the other branches of government regarding this very important issue. So what I would like to propose is, as committee chair, we will reach out to the judicial branch, see if we can't get some testimony presented to committee regarding this issue, and then to the executive branch as well, someone who can answer how is the money being allocated for the budget. And I'm glad to see lots of heads nodding up and down that we're pretty much in consensus as a committee that we want to hear more information before we decide this very important issue. Though the bill deals only with statutory speedy trial rights, it does, as Senator from Brown mentioned, does impact, though not directly, but it does impact some constitutional speedy trial rights as well if it's being set back further. We heard different dates thrown around regarding should it be May 2023, should it be May 2022. So I think these are consequential amendments that we need to look at and have all the information brought to the committee before we decide this issue. Yes, Senator Pyle and then Senator Corson.
Thank you, Madam Chair. I'm just looking at the amendment again, and the box that says providing guidelines for prioritizing trials, you know, that's very vague. Perhaps someone could show us what those guideline proposals are, you know, before we, I mean, evidently they have some idea that they want some guidelines. So what are those guidelines? That's a question I have. And then when prioritizing cases for trials, courts shall consider the relevant factors. That's all good, but maybe they need to lay that out so we can see what they're talking about, because I think that's where the lack is here. I think they failed to plan after the orders were issued by the executive branch. And the executive branch, Senator from Johnson's right, Miami, I'm not sure which is it. Anyway, but the executive branch is part of this. So they both need to come in here, show us what the guidelines are, what their plan is, because we can come up with a date. That's not a problem. But where's the plan? And to deal with what's in the box. And that's, they know they have to have some guidelines, or they wanted to come up with the amendment. And I think the people that, the two parties that put this amendment together, or however many there are, need to consider removing the strikes from the amendment, because I think that we need to keep the box in there. I know everybody likes big Christmas presents, but you know, this is one where we like a smaller package, in my opinion. Thank you, Madam Chair.
Thank you, Senator. Senator Corson and then Senator Wilborn.
I just had a quick, mostly procedural question, so I make sure that I'm proceeding in line with the chair's wishes. Would your preference be that we go ahead and prepare potential amendments, or would your preference, the chair's preference, be that we hopefully hear from the judicial branch, hear from the executive branch, understand what that testimony is, and then go to prepare amendments? I just want to make sure I'm doing what is consistent with your wishes.
Appreciate that question procedurally. If it's a different date amendment, that's relatively simple, but I think even as we consider that, I think we need to have all the information in front of us. Let's hear the plan. Let's hear the executive branch's plan as well. So appreciate the question, and I really do appreciate the question, because we want to be proceeding carefully and thoughtfully as we go forward. So that's a good idea. Thank you, Senator. Senator Wilborn.
Thank you, Madam Chairman. I get one more strike and I'll be out. What about the thought about requiring a report annually from the stakeholders as to how we're progressing with this plan, regardless of when the date is, annually. I mean, the Senate Judiciary Committee and report progress.
I think that's something that would be an amendment that would be worthwhile, a report to the legislature about how cases are being worked through, and if there's the plan that we hear, hopefully, then we will get a report on how the plan is being put into place. So any other questions or discussion or comment on 57? Yes, Senator Baumgardner.
Thank you, Madam Chair, and this really isn't directly with Senate Bill 57, but in many ways it is. We know that we are working through the budget process, and so we certainly know that Ways and Means has been addressing budgets. I think it would be appropriate for us to send a message to Ways and Means with regard to the judiciary budget, to let them know that we have significant concerns, that there has been a backlog, and share with them some of the compelling evidence that we heard in this hearing for Senate Bill 57 about all of the hearings, trials that have not occurred, and that they may want to be adjusting the budget with regard to that.
Is that something you want to take on, Senator, alerting Ways and Means of just for those listening online and watching online, the consideration of the judiciary budget did not come through Senate Judiciary Committee. So we didn't have any hearings or testimony on that. It wasn't referred to this committee. It was in Senate Ways and Means Committee. So that's why the concern of the good senator from Miami, including some of Johnson, is that we alert them that there are some concerns from this committee about that budget. If Senator would be willing to communicate that, or?
Well, I think what we have done in other committees is we have simply prepared a statement, so I'm happy to work with the reviser or someone from research with regard to that. So it is simply a statement of, we know that this is a situation that is ongoing, that it has not been resolved with regard to legislation such as Senate Bill number 57, and they need to know that currently there is not a judicial plan, there is not an executive branch plan, but we do have the attorneys that have come up with a plan that is really a 3-year plan, and so they need to know that that's not been accepted yet, and work is not being done in our courts. So I'm happy to do that and get a draft that the committee could look at.
Appreciate if you're able to take that on. Appreciate you doing that, Senator. Any other questions or comments or discussion? With that, then, we will leave open the working of Senate Bill 57. And I thank the committee for the thoughtful discussion today. I think it was good, robust discussion, hearing from a lot of different angles on how we're looking at this issue to resolve it as best we can to move forward. With that, committee, thank you for your time and those who have joined us online. And with that, we are adjourned.